Welcome back to Supreme Miss. We are taping this on Monday, July 1st. The Supreme Court has just issued 3 decisions, all of which are actually important. But on this podcast today, we're going to talk about the immunity decision mostly. My guest today is a returning guest, and there aren't that many of those, and I'm really glad she is back. Jennifer Mascott is an associate professor of law and the director of the Separation of Powers Institute at Catholic University Law School. The director of the Separation of Powers Institute is exactly the person who we should have on today to discuss both Chevron and the immunity case that came out this morning. Jennifer is clerk for Judge Kavanaugh, I believe, and Justice Thomas on the Supreme Court. She graduated George Washington Law School with the highest grade point in recorded history. She works for DOJ at the Office of Legal Counsel. Her articles, essays, blog posts, everything you can imagine are everywhere. We have been on numerous panels before. We disagree on everything, but we like each other very much. So, Jennifer, I'm really glad you're here.
I love that warm welcome. That's so great. And I love a vigorous discussion. So thank you for having me.
And I want to say one last thing before we get into the stuff. For those of you who don't know, Jennifer has gone through a really, traumatic personal life in the last few years. She tragically lost her husband. She has lost her mother. It has been a very rough several years. Jennifer has several kids, children. However, while all that is going on, she has been just amazingly productive, important, and everywhere law professors need to be. So I am really impressed with how you have dealt with everything personally and professionally, and I followed it. And I just want to say I'm sorry for your losses, and I'm so impressed with how you've handled it.
Well, that's very sweet. Thank you, Eric, very much. And it just goes to the story of community and a lot of great support here in town and in the legal academic community. So thank you for being one of those who's encouraging and patient and kind.
Well, my pleasure. Okay. Now, this morning, the court rules 6-3 that the president has immunity. What the contours of that immunity are, how it plays out, what it means, that's what we're here to talk about. I think there are 3 buckets. Do you agree? There's a 3-bucket approach.
I actually do. See, we're starting off on a good note. There are definitely 3 buckets. It's very clear.
Tell the audience what the 3 buckets are.
Well, actually, and I think this makes this a much more nuanced opinion than we realized that was going to come down. So there are the category of acts that are totally private acts for which the president can be prosecuted once he leaves office like any other normal individual. The caveat there is what's interesting is in the Clinton administration, the Justice Department issued an opinion that said when the president's in office, he cannot be criminally prosecuted, essentially, period. So that was it was not the precise issue before the court today. Nobody's actually interrupting that conclusion because here, of course, we have a former president who's being prosecuted, but for acts that took place while he was still serving his presidential term. So the court says if during the presidential term they were private acts, he leaves office, he can be prosecuted like any normal person. Then at the other end of the spectrum, there are I would say a small class of cases, and maybe Eric, you'll disagree with me, but a small class of cases for which the court says there is essentially absolute immunity in its view. And this is the core class of activity where the prosecutor's only argument would be this falls within a core purely executive function. Congress has no role. It can't be regulated. It's like 100% right within the core of executive power. Now, some folks might think that's a large bucket. Interestingly, in the court's opinion, and also with historians and a lot of scholars, a lot of folks think that's actually a fairly small bucket. So if the president's getting advice from his advisors, DOJ tells him to do something, this is actually a pretty historic view. In fact, even the special counsel attorney agreed in theory with this in the oral arguments that if the president's advised by somebody, X is legal, we're not going to criminally prosecute him for that later. So that kind of thing, pardon power, nomination power, negotiating treaties, those kinds of things, nobody can second guess and criminally prosecute. Then there is argument.
Wait, Jennifer. I'm sorry, Jennifer. Hold on. Jennifer. Wait, I've lost you.
No, I'm here.
Okay, can we pause on that big bucket for a second?
No, I think that's a small bucket.
Small bucket. I mean, the first bucket. I'm sorry, the first bucket. The first bucket being there is some bucket full of absolute immunity. We don't know how big that bucket is. Can I ask you a question about it? Because I want to go kind of issue by issue here. So if the president is walking down Fifth Avenue with the Attorney General of the United States, and they're discussing a range of official things, there's no range of them that no one's going to say is criminal or anything like that. But during that conversation, they also move on to citizen Y is a direct, clear and present danger to the national security of the United States. And by the way, look, there's Citizen Y walking down Fifth Avenue right over there. And I think as commander in chief, I have an obligation to protect the American people from this terrorist. I'm going to shoot him right now in cold blood. And the attorney general goes, "Yeah, I think you have the right to do that."
So
I
can I pause
think
you for just
that,
a second? Because
yeah,
I actually think these things all blend together. So if I can just
okay,
talk about the arguably the
sure,
biggest bucket in the
sure,
middle
sure.
is something that is an official, we think might be an official act, but the president ultimately could be prosecuted for it. It's just he starts with the presumption of immunity. So interestingly, how I read generally the opinion is that the court is essentially saying if he's doing this and it seems governmental, and unless it's manifestly and palpably clear that it's not governmental, it falls within official act where he's got a presumptive immunity. So he's going to be immune unless the government or here the special counsel can prove that it's not going to burden the functioning of government and the executive power for him to be prosecuted. So this would be carrying out statutory authority. This would be engaging in joint decisions with Congress that has a role, mind you, in national security, in foreign affairs by the Constitution, in immigration regulation, in bankruptcy, in all manner, in spending, legislating, creating the agencies, all manner of issues. And the court is saying in those cases, it is actually theoretically possible, technically possible, that the president could face criminal prosecution in those areas as a constitutional matter if the government can show that it doesn't burden the executive power. You are right. There are huge questions, huge things to be worked out after this case. I don't actually think it's useful myself or you or whoever today to spend a lot of time actually answering the hypothetical that you just mentioned, because it's just not what we have here. So I'd have to go back and look at I guess the opinion more closely. Also, quite frankly, we're scholars, we're executive power, we're constitutional scholars. As you know, there's a range of viewpoints as to what's a classic executive power. So I don't know. Do some people think that deciding who a terrorist is, only the executive has a role? Such people do exist. I mean, my sense about the wide range of scholars and jurists and whatever is that, I mean, I don't know. The countries joined conventions suggesting that we have to follow certain policies with terrorists. Congress seems to think it has a role. It issued Hamdi versus Rumsfeld. That suggests that the Supreme Court actually thinks it can limit or give some kind of regulation to the determination somebody's a terrorist. So I don't know. Can a court that issues a plurality decision saying that like Hamdi or whoever has to get due process, that then the president can unilaterally, without criminal prosecution, shoot them on the street? I don't know, maybe. And honestly, the person who I think would be most interested in the answer, that's probably President Obama with the drone strikes and not President Trump. Because I
Sure.
actually think
We
President
agree on
Obama did a
that.
lot
No,
more
we agree on that.
unilateral killing of people than has come up in Republican administrations.
Well, we agree on Obama executing an American citizen having lunch in Yemen. I think he should not have done that. We agree on that. All right, but okay. So your three buckets. Clearly, that's what the court said. Thank you. That's helpful for the audience, I think. But the court actually did two other things that make those three buckets a little more confusing. I agree with you. Let's drop the Fifth Avenue hypothetical. When I finish these next 2 points, let's talk about a real life case that's really happening, that where a judge is going to have to make some decisions. So the court says evidence of motive in trying to determine between official and unofficial acts, that can't come in. That's one
out.
thing. But let me finish. One thing is evidence of motive can't come in. Second, evidence of official acts that we all agree are official, that you and I would both agree, everybody agrees are official. Evidence of official acts cannot be used to shed light on the question, is this other act official or unofficial? Now, the Georgia judge says, okay, so we all agree President Trump called the Secretary of State of Georgia and said, find me X number of votes, which just happened to be, by coincidence, one more than he needed to win. Trump is going to say, I am just simply looking out for the integrity of federal elections. The prosecutor is going to say he is illegally coercing the Secretary of State of Georgia to do his bidding. If we can't have motive evidence, how do we get to the bottom of that?
So again, this just so the audience knows when we're taping this, the decision at this point came down about less
Fair.
than 4 hours ago.
Fair.
And also on timing, I'm just going to note that, I mean, a lot of people are saying, oh, the Supreme Court sat on this. No, no. The Supreme Court argued it in April 25th. It's now issuing a decision 2 months later. And by the way, the grand jury indictment did not come down to the summer of 2023 for actions that happened in 2021. So this is actually moving on quite a rapid track. And the Supreme Court made clear, coursing throughout the opinion, Chief Justice Roberts' opinion, that it considers these questions before it monumental ones of historic, constitutional, for all time significance. So they intentionally tried to answer it with a view much larger and broader than just this case. So I actually think, and again, I'd have to go back and read every jot and tittle of it before I wanted to say this definitively, but I think it's likely that they intentionally kept some of these questions open. And when I say that, I don't think they meant to necessarily confuse people, but like you can even see in their explanation of it, they're saying we are a court of final resort, we are a court of review. And there hasn't been a lot of scholarship, a lot of brief writing, a lot of lower court vetting of the question of where's the official act versus the private act line draw. And so the justices were really working through this during oral argument. They now have to reach a ruling for the American people. And so I think what they are doing is giving broad lines that are going to be fuzzy. And if it gets worked out in this case, it's going to have to be worked out with Jack Smith making some of these arguments. So your specific question about the interaction with the Georgia Secretary of State, I mean, it'd be interesting to go back through the oral argument, because actually John Sauer, who argued for the president, and Michael Dreeben, who argued for the special counsel, but in particular John Sauer, answered some of these things. And my understanding, again, I just quickly re-skimmed it because it's a close to a 200-page transcript. But I think John Sauer admitted, or conceded is the better word, in oral argument, that some of the behavior that was discussed, like the engaging with private attorneys who were talking about fraud, and if somebody were to talk about fraud where it didn't exist, that kind of thing would be private. If we're talking just generally in a broad class about calling up a state secretary about an official election, could that ever be official? I mean, I don't know. Are we looking at this like it's a facial versus as applied challenge? Could a president calling a state secretary of state ever be official?
Oh, I think so.
Yes.
I think yes.
Now, was it on the facts here? I am glad I don't have to argue that in court. I mean, I think Jack Smith is going to have to pour through the opinion and use the language of it, and he would have to make a legal and a factual argument, and he would have to say, based on what I understand the law to be, in X types of instances, contacting the Secretary of State would be a private act, and therefore I can show you through the facts of my indictment why it is indeed a private act. And what the more challenging thing is, obviously President Trump's people then can dispute that. And not only so, Jack Smith has to win on that to even put it into the official act, or I'm sorry, to take it out, to put it in the private act bucket. No. Do I have that backwards? If he
No,
gets it, actually, I think no. Actually, I think it actually works more on it. So Jack Smith can prosecute President Trump for that if he does either of two things. Either he could show that it's a private act, call it under the court's opinion, calling the Georgia Secretary of State, but there would have to be no there would have to manifestly and palpably be no way it was official to go into the private act. If he can reach that standard, he's done. That's all he has to show. If he can't reach that, and it's not court executive, which I mean, I don't know if anybody's ever argued and said it's a court executive function to call the state Secretary of State, but probably not. I think under
Jennifer, sorry. On that point, though, I mean, the court did say today that certain conversations with the acting Attorney General were off. Let me finish. We're off. I mean, those cannot be prosecuted. They about the Georgia call and the other stuff. They are leaving that for the lower courts. I mean, that's that. Yeah.
But the reason why the Attorney General thing, and again, we'd have to look through the opinion more in depth. But also, I think if you go back to the oral argument, the way it was argued, there was an entire discussion that I reread about 5:30 this morning from the oral argument.
I'm sorry.
So, no, it's fine. Not for this, for NBC, but I'm happy you use it here too. There was an entire discussion about this issue. And it was mostly with the special counsel attorney about this custom that we have that the attorney general is by law assigned to give the president legal advice. And this, even Michael Dreeben conceded that if the attorney general advises the president something is legal, and then it turns out later that there was a mistake and it's not, and it turns out to actually be criminal, that we have a culture of immunity and trust and due process, that we're not going to prosecute the president. And quite frankly, the custom is that lower level officials aren't prosecuted in that instance either. That's why the office where I used to work, the Office of Legal Counsel, sometimes is asked to pronounce opinions on it. So you actually have a written record that you have been told X, Y, and Z is lawful. And if it turns out not to be, you don't face criminal sanctions for it, which is the government ceases the practice. So,
Okay.
so that I think is where they're coming from with the inherent executive function. So let's just say it's not that, and it's this big bucket. Then Jack Smith can't show it's totally private, but he could still prosecute it if he can show that going after it doesn't burden the function of the presidency. And so he's going to have to make legal, I think, and factual arguments about that.
Okay. Well, hold on. So
Don't
two things.
you?
I
For
want
the
to push back.
Secretary of State
Hold on.
question?
You said a lot there, and I'm only going to put. I'm by the way, for this podcast, as all podcasts, silence is not assent. But I want to push back on two things that you said about the delay issue. Let's remember that this court has, unlike previous courts over the last 6 years, and part of this is COVID, so part of this is understandable, has bypassed the Court of Appeals on occasion when they thought it was important to do so. They did so this term in the abortion case, then decided it wasn't the right thing to do, but they did bypass the Court of Appeals. What I want to say is this case could have been decided faster by simply, like they did in U.S. versus Nixon, like they did in Steel Seizure, by simply bypassing the Court of Appeals. That delay took out months at a time. But I don't want those. What I just said are facts. In both Steel Seizure and Nixon, they bypassed the Court of Appeals. Here, they were asked to bypass the Court of Appeals, and they didn't. So that we can disagree about the implications of all that, but those things are true. The second thing I want to ask you about, and this is really important. I think a lot of my Twitter both lawyer and non-lawyer friends are really curious about this. Your point about it being 4 hours old or less, actually, is a really good point. So we're not going to solve the world's problems today. But we have both read the opinion, and so here's my question. So the Attorney General of the United States, let's say John Mitchell, who in fact went to prison, the Attorney General of the United States gives the president legal advice that the Attorney General subjectively knows is false, and no reasonable person should rely on. As I read the court's opinion today, the president cannot be prosecuted, even if both actors are acting in bad faith, even in a hypothetical situation where both actors are acting in bad faith. Now, is that true based on the writing in the opinion is one question. Will the court stick to that if we had that case? No, of course not. I think you and I agree on that. If the Attorney General told the president to execute Siegel because he's been a pain in the ass and they had no legal reason for doing so, the president would probably be prosecuted for that. But as it's written today, I don't see it. I mean, it says, like you just said, if the Attorney General gives the president advice, it's over. But what if that advice is in bad faith? What if they collude to get bad advice?
So, Eric, you're asking me what the opinion says, how it would be resolved in the opinion. And I consider that to be a request for gold standard legal advice. So, in keeping with the voluntary nature of the podcast, I'm just going to give you some thoughts and not definitively answer it, because I'm confident that smart attorneys could argue that one way. I actually happen to agree with you that I think the whole just idea, separate and apart from this case in the opinion, the whole idea that the president supervises the attorney general, and then that anybody in the Justice Department could ever, in some reasonable way, actually advise a president on thorny issues, raises all kinds of complicated questions and actually gets to the pulse of why the whole office of the special counsel is weird and odd in the first place. Because the current sitting president, for example, is in charge now essentially of an investigation of his political rival, and really, as a constitutional matter, should be able to fire his attorney general and other people. So the good news for our system is that whether or not There could be a criminal prosecution in the factual scenario you mentioned. There could be impeachment and conviction because obviously, if the president and the attorney general are colluding about clearly illegal and unconstitutional things, they are not. Neither of them is following their duty to take care that the law be faithfully executed. So, in that hypothetical where we have a truly lawless system, where both the Department of Justice, and the president of the United States, elected by the smart, diligent American people, are inherently corrupt, we do have a problem. And yes, it is indeed the case that that the fact that the attorney general is subordinate to the president obviously creates an inherent conflict of interest in the attorney general giving him legal advice. And that's why we need impeachment, why we need conviction, why we need Congress, why we need an informed American public, so that we can all be reading statutes, be aware with our own eyes, and look out for such a dereliction of duty. Thank goodness in our system of government, we generally elect people who are really trying to follow their constitutional oath and do what they believe is in the best interest of the American public.
That's that's totally fair. Yeah, that's fair. Sandy Levinson, who I think we all respect, whether we agree with him politically or not. Sandy said something today on my nerdy con law list that I think is interesting, and then some other people said it on Twitter too. I think. I guess I'm going to. This is a concession to you here. I think. I think it's fair to say that it's very hard to devise a system of representative constitutional democracy / republic, whatever that means, for the bad actor president. Like if we have a bad actor president, it is very hard to devise a system to deal with that problem. And I don't, so I want to be clear. I'm sorry, Jennifer, I need a second here. I need to be clear to my audience that I am very, very critical of this opinion. I think it came out wrongly and badly. That's one hand. On the other hand, I am not diminishing how hard this issue is, how complicated. You're exactly right about that, how hard it is, and how hard it is to construct a system that allows good presidents to do allows good presidents, I don't mean good and I like them, I mean lawful presidents to do
Right.
lawful things, and
Mhm.
unlawful presidents to get them not to do unlawful things. That's a very tough system to construct. So
Sure.
you want to add anything to that? 'Cause I think that's fair. We agree on all of that, I think.
No, I agree with that. And actually, if you go back and read the Federalist Papers, they sort of said the same. I mean, the assumption early on was that the system was going to work because we assumed the American people were going to be electing qualified folks. And that's why we have a minimum age of 35 for president. That's why we have the Electoral College. That's why there were lots of checks in place. It's also why we have divided government in case we didn't. And
Right.
quite frankly, you and I also probably agree that one of the biggest challenges we face in our current system is that the executive branch right now has such a large share of the power, whether you're thinking about the president or administrative agency, and therefore the stakes are so much higher than they would have been a couple hundred years ago.
I agree with that. Is there anything else you want to say about the immunity case before we get to your real, I think your real love, I could be wrong about this, but your real love, which is administrative law and Chevron and everything that's going on in that neck of the woods. Is there anything else you want to say about the immunity?
I don't have anything more to say today except just that it
Good.
is an unprecedented case and situation. And I just very, very interesting issues. And again, I'm just going to say positively about all nine justices. I just really do believe that all of those justices are trying their hardest to come up with the most constitutional, lawfully correct decision that they can in this case and others. And when we see these big differences, it's because the justices just sometimes have radically different views about what their constitutional role is or about how the constitutional protections that we all hold so dear are supposed to play out. But I do think they're motivated, all of them, to try to serve the country and do the right thing. And I will also say, I left the Administrative Law Center to start the Separation of Powers Center. So actually, I do think my greatest love is just this broader
Okay.
intersection of issues about who gets power in our system, what authorizes any actor to do anything on behalf of the American people, and then how do we keep them accountable once they've acted? And that is really at the crux of today's decision, and to a certain degree about the Loper Bright decision that you're going to steer us to next.
Yes. I had a flashback when you were saying that to my very first day of law school back in
All right.
1983. I'm sorry, 1980. I don't believe you were born. Back in 1980, and on con law on the board, and I was hooked from this
Aw.
moment. I mean, I was hooked from this moment. on the board were two words in huge letters. This is long before computers and so it's on the board. Who decides? And I do think a lot of what you just said also really who decides is always the core question, I think, of constitutional law and separation of powers. And I just had that flashback when you said that, because I think what you said was right. And I think who decides is always going to be, at the end of the day, the question. Who gets to resolve this issue finally? All right. So I'm going to talk for about a minute and a half, and then you can yell at me. Okay.
I never yell.
So
I even have 4 children, and I
you-
rarely yell.
yeah. Now that is impressive. Well, we'll bring you back in about 6 months for that
Okay.
podcast. I have three daughters, and I would love to discuss that. But okay. Here's my tagline on Twitter today. Here's what I'm saying in all the podcasts I'm doing for other people, and I'm doing on TV tonight. It's this, and Jennifer is not going to agree with this, people. So let me get it all out, and then she'll tell you why
Okay.
I'm wrong. This term of the Supreme Court, to me, was about making it easier for the president to be a criminal. I think you disagree with that, but I don't. I think this case today makes it easier for the president to be a criminal, but much harder for the president to actually be president. Because while there's no question in my mind that the immunity opinion is broader than most of us thought it was going to be in terms of immunity, of course, the court has been taking power away from administrative agencies. Before we discuss the pros, so on the one hand, personally, the president's doing great, but officially and professionally, he's not doing so great if we believe the Roberts Court and their administrative law decisions. My first question, before you yell at me, is it a fair factual statement? Is it a fair summary of seal of law, which I think was 2012? If I'm wrong about that, somebody will correct me. But around 2010 or 12, the court, since seal of law was decided, the court has absolutely made it harder, maybe more legal in your views, but harder for the administrative branch, for the administrative state to act. Oh, can we at least agree on that? It is harder today for the administrative state to act than it was in 2012 by a substantial
Well,
margin.
Sail Law was 2020.
Okay,
So
sorry.
um,
I'm thinking of the other case.
you're
I'm thinking
thinking
of
of
the other one.
you're thinking of the Peekaboo Free Enterprise
Yes.
Fund case with removal projections.
Yes.
Has the
Yes.
court made it
Yes.
tougher for them to act?
I mean, taking into account all of
I'd
it.
have
taking
to go.
share-
So
no,
I was been a couple months since I closed the book in my administrative law class. I would have to go back and look, because the thing about it is Chevron is the deference on the law, but we've got State Farm deference on policy discretion. And I actually think in some ways the court has loosened up and given more deference in the policy space. So
Could you explain that, Jennifer? Could you explain that? I'm sorry. Could you explain that?
I'd be happy to explain it. So when we talk
Yeah,
about the Chevron decision in more depth, we tend to want to simplify it and say, oh my gosh, now the court has taken away deference to agencies. But what's really important in administrative law class, and this is so eggheady, I hate to bore your listeners with it, but there are multiple just types of decisions that the courts can review of administrative agencies. There are fact decisions, there are law decisions, and there are policy decisions. So on the factual determinations, it's essentially close to a jury standard. The court hasn't really done much monkeying around with that standard in the APA in recent years. So we'll just take that off the table. Then there are questions of
fair.
law, which is essentially, what does the statutory term mean? How broad is the power that the agency has been given? So the court's decision on Friday essentially said, we interpret the Administrative Procedure Act to leave those questions up to the judicial system. They are primarily in charge of deciding what the statute means and how broad the range of power is that the agencies have been given. Then there's a third type of deference, policy deference. So let's say that the courts conclude the statutory term is broad, that safe means a wide range of things. Better does mean better empirically than worse, but it could mean a lot. Well, then under the Administrative Procedure Act, the courts have to defer to the agencies so long as the agencies haven't acted in an arbitrary or capricious fashion. Now, back in the day, in the 1980s, the court was fairly trenchant in that. And it said, well, arbitrary capricious doesn't just mean everything except something crazy goes. We actually need to see the reasoning. We need to understand what the agency did. They need to have considered alternatives. Some of us think that was actually atextual, and that the court should be giving more deference to agencies for the policy, because once Congress is given the power, Let's let the executors do it. And I do think if you look at some of the decisions for the past 5 to 10 years, the Supreme Court has issued decisions that loosen that up a little bit, and they're maybe being a little bit more persuaded. And for litigants who want agencies to have more power, perhaps that is a pressure point that they can press on a little bit more and get the courts to sort of revisit how trenchant they're going to be in arbitrary capricious review, because I think there could really be a lot of deference there. And so that's why I'm hedging on answering your question one particular way.
Okay, that's fair. Talking about Chevron. So what I think what the court held was on issues of law, uh, lower court judges and the Supreme Court look at what the statute means with the same degree of latitude as the agencies. They don't defer to the
Correct.
agencies. Okay. I have a question. Could Congress amend the Administrative Procedure Act tomorrow and say we prefer the system of governance that was in place in the 80s and 90s before Chevron was abandoned in practice by the court? Or we want to go back to Chevron being a real thing. We want federal judges to defer to all reasonable interpretations of statutory language. That is what the Congress wants and intends. I believe Justice Thomas, in a concurring opinion, thought there were constitutional problems with that. I don't think the other justices opined either way, so I'm not going to attribute to any of them any. Thomas clearly brought that issue to the surface. Do you have an answer to that question? Do you have a personal feeling about that question?
So I think that you're correct that under the Loper Bright decision, that it is an open question and that Congress could feel free to change the standard of judicial review. Would there be a constitutional problem with Congress saying we want to leave it up to the agencies to act reasonably? So, to be perfectly frank, that is a question. Look, we're scholars. Before we answer anything, we want to write a 100-page law review article studying it. I mean, if anybody knows me, they know I probably sin in that area greater than the rest of us because of my 120-page Stanford article on officers. Um,
Yes.
so I can't definitively answer that on this podcast. I mean, obviously, I have some
Okay.
constitutional concerns about. I think if agencies are straying into areas where what they are doing is, as a practical matter, creating an entirely new legal requirement that Congress has not authorized or foreseen or guided in some fashion, that's
Well, okay, stop. Wait, Jennifer. That's
that's a
great. That's great. Let's
delegation
stop right there.
problem. Okay.
Hold on. I have that case for you, and it involves me, so
Okay.
it's good. Let's put that. This really happened. Let's put it crystal clear. Congress decides in 1989 or 90, don't quote me, no more money to the National Endowment for the Arts to fund obscenity. The National Endowment for the Arts gives grants out to artists. They had been giving some grants that some people back then thought were improper. This is what the law said. I'm paraphrasing, but it's what it said. No more funding for obscene art. Executive branch define obscenity for the purposes of this law. Michael Paulson, who you know, I'm sure, one of our funniest, I think, and most conservative law professors in America. He and I at the LJ went into a room together and defined obscenity for purposes of the NEA funding mechanism. It went into CFR, whatever those things are, had the force of law.
Eric, I'm not
Is
going
that
to
a
disagree. Look,
proper?
as a former DOJ employee, I love being a DOJ. And I have to just say, I think the DOJ attorneys are some of the smartest, finest,
Me
most
too.
well-motivated attorneys in the country. And I could not have even imagined how wonderful of a time I would have had working with the political appointees and the career appointees alike. And quite frankly, I've heard many career appointees talk about how consistent the executive branch position is across administration. So I just want to say that first off. And also, I point out a lot of times in teaching my classes how ironic and weird it is in our system of electoral government that there are mid-level bureaucrats in the Department of Justice making big decisions. So, Eric, you got to define obscenity. Well, my boss, one level up, Steve Engel, the Assistant Attorney General for the Office of Legal Counsel, is literally asked across administration now for decades to answer, when can a president unilaterally use force? I mean, if you think about it just from a common sense, superficial standpoint, it seems wildly incongruent with our system of government. Now, just for your listeners to understand, there's a rhyme or reason for it. And actually, technically speaking, it's congressionally authorized because all of this power derives from 1789, essentially, when Congress assigned the Attorney General with the power and the responsibility to interpret law and advise the Attorney General on questions of law. So there's a quite formal system within the Department of Justice delegating that down to Senate confirmed officials or at least AG confirmed officials, and you have to get an order delegating it down. And then, of course, it's supervised. But the reality at the end of the day is yes, there are smart attorneys like you, but non-elected attorneys making some of these decisions. And so, quite frankly, I would urge the members of Congress to think through whether they want to be enacting laws that are delegating those decisions to the Justice Department. Is it a constitutional problem? So I think the one interesting wrinkle, and I have to go back and look at how that statute was written that you mentioned. I mean, I do think, is there a different delegation standard when we're talking about appropriating money versus Commerce Clause?
Fair,
Because when you're
fair, yes,
appropriating
fair.
money, you're not actually creating new law. What you're doing is you're giving a benefit and you're using the different power of Congress to give out things. And so there are some political costs there that make it hard to do that. Like you have to raise taxes, um, and things that I think the founders thought was going to make it less likely people were going to be able to pass taxing and spending bills. So they weren't quite as concerned about the political constraints on dividing up the lawmaking authority that they are in new burdens. Could they delegate to you the power to find a sending? I mean, I think, look, some people would say yes, some people would say no. We haven't really interestingly had any cases this term answering that question. The court declined to get into it in the Jarkissi case. I think it's going to be a really long time before the court changes us from our current standard, which is that Congress only has to give an intelligible principle for it to be a constitutional delegation of power in the policymaking space. Because I think there are multiple justices who are concerned that no scholar, no historian has come up with some clear-cut way to be able to discern how much instruction Congress has to give to the executive branch. And you know what? It might, if we're being really honest, it's possible that as a constitutional matter, the answer could be slightly different depending on the significance of the power we're wielding, right? Like if a new agency is being created, hopefully we think Congress should give more standards than if we're talking about Congress coming up with regulations that are going to impact 1,000th of 1% of the economy. But that is not something that I have constitutionally studied. So I'm going to have to leave that
But
for
that
another
that
day.
last point that last point is fascinating, and it really is, because when I engage in debates with people on Congress's authority to delegate power to the executive, and I mention that George Washington was basically given $1 million and said, "Spend it, don't spend it, do what you want," an ultimate delegation. But your answer, which is fair, your answer, based on what you said, would be okay. But we're starting a new country. We don't have to have, when you start a new country, maybe different rules apply than when you've had a country for 200 years. I think that's a fair response to my historical point. I do. But having said that, so it was interesting. Intelligible principle. So for the non-lawyers in the room, intelligible principle is currently the standard for delegation. And it's interesting because I'd have to go back and look at the law myself. It's been a long time. But I think depends how you look at intelligible principle. We knew what our task was. Our task wasn't, cloudy. Our task was to find obscenity for purposes of the federal government giving money to artists. They're not allowed to fund obscenity. That's a very narrow, self-limiting task. But there was no advice given how to do it.
Well,
None.
did
Just,
the assistant attorney general have to sign off on your analysis? Did the AG sign off on his supervision of the analysis? And could
right,
the president have
right.
overridden it?
So that's a great question. Only somebody with your pragmatic and practical experience. I know this after 124 podcasts. Law professors without real life experience would likely not ask that question. Law professors with real life experience would ask that question, and that's why you're so valuable to our academic world, because you have both. You have both the practical experience and the academics. What I want to say is, and this is, I got to pause for a second to make sure I don't do something that could get me arrested. I think it's fair. I think Paulson would answer the same way. Yes, of course, technically, a political appointee had to eventually sign on. Yes, and that's how it should be. However, they both, the powers that be at the time knew we both wanted to be law professors. We both ended up being law professors. They knew we had an academic interest in con law and this kind of stuff. And we knew we were not going to be second guessed. Like, we knew only if we did something terrible, obviously stupid, would we be second guessed. It turns out, just so you know, what we decided was we can't define obscenity. Justice Stewart couldn't define obscenity.
Oh
We're not going to
no,
try.
did you go
We'll just
watch a lot of videos to
wait.
try to figure out what it meant?
No, no, we did not. No, I swear, Mike. I want to say Michael wanted to, and I didn't, but I'm not going to say that. That wouldn't be true. Um, what I will. That's great. That's very funny. What I want to. What I want. That's really funny. What I want to say is, all we did was define it as the Miller test, which is the test for obscenity under the First Amendment. We said if the First Amendment allows it to be, if the First Amendment allows it to be criminalized, we don't have to fund it. And if it's not, if it doesn't meet the, and which we thought was a really, Michael and I would, we couldn't, he's even more different than you and I are. I mean, we couldn't be more different politically. Michael has called abortion a Holocaust. We couldn't be more different. But the funny thing about
But
that
can I
story
also pause
is,
there just because also
yeah,
it should be
yeah,
noted that Michael Paulson's more recent work, for which he's well known, was co-authoring a piece with Will Bode that actually
yes,
went
yes,
down on the anti-Republican president
yes,
side most recently. So just, I mean,
yes,
if I don't know his political views, but if they are as you
I
say they
do.
are, then he just in a very high stakes situation co-authored a piece that would come down on the opposite side.
Well, right. Well, I mean, he and Will hate Trump, but that's okay. It doesn't matter. Michael's a good guy, and he is, I think, one of the funniest law professors in America. So if you ever get a chance, if anybody listening to this gets a chance to hear Michael Paulson speak, you should. He's very funny. He and I have been on 2 panels together on Section 3, so I'm very familiar with all that. My only point was, um, we had a great deal of confidence that we would not be second guessed. We weren't second guessed, but it turns out, and can you think of a better way of doing it than just, well, the court has defined obscenity this way, so we're going to use the court's definition. A crazy, progressive, radical judge in San Diego struck it down as unconstitutional, even though we used the
That's
Miller
interesting.
test in an opinion, in an incredibly horrible opinion. So not only did I draft a law with Michael, but we drafted a law that was struck down, but the Congress then, it was going to be appealed, and the DOJ was not happy with that decision. The Bush administration DOJ was not happy with that decision. But turns out Congress repealed the law, so it didn't matter. But it does get us to what we were talking about, which is, and then I want to spend this 5 minutes on this, dropping all kind of legal
Okay.
stuff. We have a 3,000-mile country from New York to California, plus Hawaii, plus Alaska, plus Puerto Rico and Guam. We have 400 million citizens, give or take, Americans, excuse me, or people living here. And I think one of the things that gets lost at a very high level of generality, so we're not going to solve anything today, you and me, but it's really hard to govern a country that way. Like we're diverse, we're regionally different, we're spread out, and we're a democracy. It's easy for a tyrant, it's easy for a dictator, but thank God we don't have that. So it's really challenging. Some degree of delegation to the executive branch seems inevitable, unless we're going to go to a completely states' rights type world, but I think that ship has sailed. So how do you balance those, Jennifer, not any specific case, just as a matter of values, how do you balance the difficulty, especially with the filibuster, of congressional legislation with the reality that nobody wants everything delegated to unelected, civil service members? How do we think about that in a way that can bring people of opposing sides together? That's my
I
real
mean,
question. How
to
can we
be
think about
honest, I do think you do need the balance of thinking about power at the states level, and that it's not all just extreme states' rights versus states do nothing, and that actually there is a movement and there's a multi-party movement toward thinking about that more. There are some scholars who are writing more in the states federalism space. There's cooperative federalism. For the past couple of years, have spoken in December to the National Attorney General's conference, and I think there were folks there who are thinking about what's the responsibility of state attorneys general. And so it is. I mean, the reality of it is that when the main body of the Constitution was written in and ratified in 1788, the understanding was going to be that there were going to be a lot of different solutions from states. And so unfortunately our country's worked remarkably well for well over 200 years, and we're about to, thank goodness, celebrate another birthday of our independence just later this week, which I'm so excited about. But so we have to have the states, they have to have power. The federal government was never designed to do anything. Also, to give context, so I did write a piece on the customs laws and the debates in the late 1700s. And when you get to Congress, the reason I think, look, it's not just a theoretical constitutional matter. Oh, legislative power means Congress has to do everything. It was actually, I think, had real representative democracy implications. And you can see in the debates, for example, on the customs laws and these finely grained duties that are different based on type of good and subdivision of type of alcohol, et cetera, et cetera. The regions of the country, the North was going to benefit differently from tariffs on certain goods than what was going to happen with the South, and then what's going to happen more in the Western regions. And so the reason that the Congress got together to make the decisions was because it's just a much more granular, full-bodied way to be able to represent the interest in this country, even at the federal level, than if one president or one cabinet secretary makes the decisions. As a practical matter today, what do we do? Well, quite frankly, we could learn from their example, because even back in the day, Congress asked and received a lot of advice from Treasury Secretary Hamilton on a lot of these questions. So we could consult and get even more expertise and actually listen to the expertise of the agencies. And quite frankly, I'm actually a big fan of the procedural solution of thinking more about, at least in some cases, should we change the default rule about when regulations become law? So we do have this law in place called the Congressional Review Act, which gives a mechanism for Congress to rapidly bypass the filibuster and essentially disapprove with the president's signature of a particular regulation. And if it's disapproved, then a similar regulation cannot be put in place ever again unless Congress passes law saying it can. You could switch the default switch where with some, if a regulation was significant over a certain amount of money or policy decisions or whatever. I don't know how you'd frame it. But the agency would have to come and get congressional approval for it before it goes forward. Now, the political realities are such that may never become law. That may never become the default rule, because members of Congress have political incentives not to make detailed decisions. They all have to get together, they all have to compromise, and then they have to take political cost if something goes awry. So they want to kick it to bureaucrats who are not elected. And we should just all be honest about the reason that is happening. The reason that is happening is because the system wants to flee from electoral accountability. And so at the end of the day, I think we as Americans have to decide, would we rather have a system in place where decisions are easy, but we don't have a say, or we have a say and sometimes the system is inefficient? And I think being aware of that tension, being cognizant of it, not fleeing from it, not hiding our heads in the sand, is going to make us a better country, and when we're going to continue to have frequent, vigorous political debates and try to bring some accountability and transparency to the system. And I just hope that this lovely democracy that we live in safely right now, many of us, and that is continuing to strive to become better and become more free and become more equal and become more diverse and more appreciative and recognize more the dignity of every human, that hopefully it will continue to exist for hundreds of years to come. But I think our divided federal state system and our 3-branch federal system has been really integral to it. And I'm so happy that you had this podcast today to discuss all of those um,
Okay.
principles.
We have about 5 to 8 minutes left, so I have a quick follow-up to what you just said, and then one last question. That quick follow-up is: Congress can't veto a federal regulation without going back to the
Correct.
president or overriding a president's
Right.
veto. I want to make sure we're on the same page on that. Okay. Here's my question. And so, as listeners to this podcast know, I say this all the time. I send a rough roadmap to my guests, and we usually stick to it. We've done pretty well, I think, sticking to it. I have one last question that wasn't on that roadmap. If you don't want to answer it, you don't have to. But it hit me as I was talking to you, and I actually think it's a really good question. So, but no one, so totally okay if you say no. So, I wrote a blog post last week, you might have seen it, about Justice Kavanaugh's umpire doubling down on Justice Roberts' umpire confirmation statement. He did that in a concurring opinion where he literally doubles down on it. Says, I agree with Justice Roberts that judges are umpires, should be umpires. And here's my question. You clerked for Judge
Yes.
Kavanaugh, right? You clerked for Judge Kavanaugh and you clerked for Justice Thomas. I'm not trying to be tricky here, and I'm not playing gotcha in any way. It's a question I am sincerely interested in. Do you think Justice Thomas thinks that judges should be umpires, like Kavanaugh does and Roberts does?
Well, I mean, I think to a certain degree they all do, and that, I mean, where that analogy, if I take it at its highest level, is coming from, is I think it's a proxy for the instruction in Article 3 that judges are supposed to resolve cases and controversies. So if what we're saying is we don't want the judges to win the game, we don't want them to be on the playing field making a difference, being a Republican or a Democrat, being Congress or the president, then yes, I think they all nine would say we are outside of the game. How that gets worked out in an individual decision might vary justice by justice. Some might say, oh, well, the way we stay out of the fray is by being even handed and making sure the outcome of our decision doesn't look like it's favoring one over the other. Another justice might say, well, the way we can be the umpire is just in the purest, most accurate way possible, interpreting what the Constitution means. And if the court's asked about a broad term, that might mean a broad decision. If it's asked about a narrow term, it might mean a narrow decision. The third piece is, and actually this is an area where I think if you read some of Justice Thomas's separate writings in the last couple of years, he and others are really starting to think about, Justice Gorsuch as well. Then there's this third piece, regardless of where they come on the substance of the question before them, what do they think is the proper remedy of how the court should address the question moving forward? And maybe the remedy shouldn't be severing or striking a whole piece of a statute. Maybe it shouldn't be pronouncing an entire program unconstitutional. Maybe it should be actually deciding with the parties before it who wins. And so in that case, I actually think you see some really clear separate writings from Justice Thomas recently wrestling with that and saying the answer to that should be really quite modest. And even when we know we've got the right constitutional answer, we as the court can't be reworking the whole system. So again, I think it's one of those things where it's like the meaning of it is a little bit in the eye of the beholder and the person saying it.
I think that's a really thoughtful answer, Jennifer. Thank you. I think that's a really helpful answer to pretty much anybody who's thought about that issue. I will say Professor Richard Kay at the University of Connecticut, one of the originalists, he's still with us. Richard's a great guy. Richard would say, apropos to what you just said, that one of the things we've lost over the years, and I think this can be normatively debated, but one of the things that we've lost over the years is this idea that what the court is really supposed to do is say who wins and who loses. And if they who wins this case. And if they just stick to who wins this case in the narrowest way possible to decide this case, unless some kind of economic calamity requires more guidance. And that happens. We agree that happens sometimes. But in the run-of-the-mill case, just say plaintiff wins, here's why. Defendant, I would like that system. I get the sense you might like that system a little better.
Well, just as an historical note, and actually Steve Sachs from Harvard made this point at a recent conference we were all at, that it back in history, actually, it was really just the judgment that the justices agreed on, and then they sort of wrote seriatim their opinions. We didn't have all of this, oh, I'm going to agree with 93.5% of the majority opinion, and on this 6.5%, I've got my own view.
Yes.
This is like a new thing.
Yes. Yeah, they all concurring in part, dissenting in part to Section 3E.
I'm glad about you. I'm like flipping back. I got to figure out which is part 3. Is this A?
Yes.
Is it D?
Yes.
Part 4?
Yes.
I don't know. It's hard.
Yes. I think Richard's work, for those listening here, would be of interest to a lot of people. He's not one of the young gun originalists, but he's been around a long time and he's very thoughtful. And I want to promote him. Jennifer, I know you're in great demand today. Thank you so much for being here. This has been so much fun. I've learned a lot. I hope we've role modeled something, because I think we both could find a lot of areas of disagreement, but I think everything you said is reasonable. And I hope you think, where I disagree is reasonable, and we just move on and try to do the best we can.
I feel so welcome here, and I'm so grateful for you reaching out and giving a voice to these important issues. And thank you so much for all your work for students and for the Academy.
Well, thank you, Jennifer. You too. And this hopefully will come out in a very timely fashion. But
Sounds great. All right. See you soon.
Okay.
Bye.
Yeah.